All right. All right. Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Tuesday, March 12th, 2024. We're going to operate off of voting list number 10. Apologies for our delayed start. We had a number of work groups working on legislation with stakeholders throughout the day, so we got a little bit of a delayed start. We're going to start off with a few local bills. 1108. Who's counsel for that? Shamari.
Senate Bill 1108 is an emergency bill that requires that every deputy clerk or deputy sheriff in Carroll County take and sign the oath or affirmation of office prescribed by Article 1 and Section 9 of the Maryland Constitution. There are no amendments, and you should have a delegation letter in your packet.
All right, this motion for a favorable. It's in second and further discussion. All right, is everyone okay being recorded in the affirmative? All right, yes. Senate Bill 1108 passes unanimously. Senate, is that you, Josh? Senate Bill 838.
Senate Bill 838 authorizes specified officers of a volunteer fire company and the fire police of a volunteer fire company to equip their privately owned vehicles with red or red and white lights and signal devices in accordance with existing provisions. Under the bill, the fire police of a volunteer fire company would also be able to equip their privately owned vehicles with red and green lights or signal devices.
Motions for favorable. It's been seconded. Is further discussion? All right, is everyone okay being recorded in the affirmative? Yeah. Senate Bill 838 passes unanimously. All right, Senate Bill 1004.
Senate Bill 1004 reinstates and makes permanent a temporary requirement for the MVA to make available specially designed vintage reproduction registration plates. The MVA must charge an initial $100 fee and a renewal fee of $20 for the plates. You have an amendment in your packet from the sponsor. It's number 483029/1. The amendment would simply raise the renewal fee from $20 to $25.
All right, I'm going to move the amendment. Amendment's moved, seconded. Now the bill's before you with the amendment. Motions for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Yes. All right, Senate Bill 1004 with amendment passes unanimously. I go to Senate Bill 1003. Is that you, Josh? Yep.
Senate Bill 1003 conforms the statutory method that constitutes receipt of an order from a licensed vehicle dealer or distributor. Specifically, a manufacturer, distributor, or factory branch must deliver certain new vehicles and truck component parts after submission of an order or acceptance of an allocation rather than after receipt of a written order. There's an amendment in your packet from the sponsor. It's number 443825/1. So instead of making the changes described, it would simply clarify that an order may be written or electronic.
Amendment's moved and seconded. Now the bill's before you with the amendment. Further discussion. Motions for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? All right, Senate Bill 1003 with amendment passes unanimously. Senate Bill 1036. Josh.
Senate Bill 1036 establishes the task force on the creation of a division of returning citizens and expanded reentry services staffed by the Department of Public Safety and Correctional Services. There are two amendments in your packet from the sponsor. Number 153427/1 adds the Office of the Attorney General to the task force. And number 343028/1 adds the Division of Parole and Probation to the task force.
Just 1 second. Folks, take a couple of minutes just to look through the membership if you have ideas for additional members. This could potentially be a significant task force. Just take a look. And then while that's happening, I want to offer the amendment language and someone, Josh, our task force language?
Yeah, so it would be inserted in that an appointed member of the task force serves at the pleasure of the person who appointed them. And there would additionally be a requirement that at the first meeting after the bill's effective date, the task force would be required to adopt a code of conduct for its members.
I'd like to. No, we put that on a bill on the floor. Yeah, but we've been doing that for every task force. I'd like to move that amendment. Is everyone okay with that? Seconded? Is everyone okay with that? All right. Just take a quick view of the membership. We also have, did we adopt the sponsor amendments yet?
No, you're not.
All right, can we move the sponsor amendments? All right, seconded. Okay, everyone's good. I'll co-sponsor the bill with you. I'll jump on. Just take a quick view of the membership, and then if there are no ideas, then we can move forward with the bill. All right. Yeah,
Now
because
it's four.
it's a sponsor amendment. Yeah.
Yeah.
All right, now the bill is before you as amended. It's been seconded, it's been moved, it's been seconded. Is everyone okay being recorded in the affirmative? All right, stand up. I'm sorry, go ahead. Yep, Senator Sidnor.
Bill page 2, lines 19 through 21. And I'm just saying for clarification, it says 3 representatives from county workforce development, 2 representatives from county reentry organization. I'm assuming that we read county as inclusive of Baltimore City.
I think so, but it's question for now.
I believe so, but you could also say from county workforce development programs or workforce development programs in Baltimore City if you wanted to. We occasionally clarify that, but normally Baltimore City is counted as a county.
All right, is everyone okay being recorded in the affirmative? Senate Bill 1036 with amendments passes unanimously. All right, so Senate Bill, can we do this? We have to do them each separately.
It would be helpful.
Okay. Senate Bill 755 there's a motion for unfavorable because it's been withdrawn.
Second.
Seconded, is everyone okay? All right. Senate Bill 884 is a motion for an unfavorable withdrawn. Okay. 884. Senate Bill 1017 is a motion for unfavorable because it's been withdrawn. Is everyone okay being recorded? Okay, great. Senate Bill 840.
Senate Bill 840 alters the definition of historical data as it applies to the use of captured license plate data provisions from license plate readers stored to include automatic license plate reader data stored through cloud computing, and establishes that such data is the property of the law enforcement agency that captured it and may not be sold for any purpose. There is an amendment in your packet from the sponsor. It's number 623125/1. The amendment clarifies that that data may not be sold or accessed in certain ways by contractors in addition to the law enforcement agencies. And it requires law enforcement agencies to have policies to protect personal identifying information and deal with data breaches.
He's explained it well. If there are no questions, I would move the bill.
We'll move the amendments first. Or you want to move the amendments?
yeah,
All right, is everyone okay adopting the amendments? All right, now the bill is before you as amended. Further discussion. All right, his motion for favorable has been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 840 passes unanimously with amendments. All right, Josh, we're going to stick with you for one more. with Senator Carter, Senate Bill 71, since we received B&T approval.
Senate Bill 71 requires the Division of Correction to allow a pregnant woman classified to be in pre-release status to relocate to the pre-release unit for women throughout the duration of her pregnancy. The division must also allow an incarcerated individual who is classified to be in pre-release status and recently gave birth to her child to reside in the pre-release unit for women for up to 1 year following the birth. Further, the division must allow the father or secondary caretaker of a child residing at the pre-release unit liberal visitation with the child if that visitation is otherwise legally allowed, and must allow an incarcerated individual at the correctional institution for women liberal visitation with her child. Finally, the bill establishes the Healthy Start Bonding Program with the stated purpose to facilitate strong bonds between incarcerated women and their children.
All right, so the bill's before you clean, but for what is it? Because we have budget and tax approval, so on the merits, it's clean. I don't want to mess with the bill, but I do think it's worth talking about a study to understand why women are getting pregnant in prison when they're sent into a facility in which they're incarcerated for 18 months or for a minimum of 18 months. So I think it would be frankly worthwhile for us to explore that, if not here in this vehicle, but maybe in next year, just to understand that, because it's somewhat perplexing to me. So I just put it out there for discussion. Senator Carter.
No, thank you. I'm sorry. I didn't mean to interrupt you. No, I agree with you. I think it's worth studying. I think we should know what's going on. And if you wanted to add something on this bill, I wouldn't even have a problem with it. But we could actually see if anybody at all is affected.
Yeah.
And then come back and see, you know, what I don't anticipate there's a large number of individuals that this bill impacts. So
I know that, I mean, there's like, you know, when you're close to pre-release, there are like certain programs where you're allowed to go to, you know, sessions or therapy or whatever. I don't know. And so I don't want to mess with this bill, but we should come back and figure that out.
people are married
Yeah,
in prison. Some are.
That's true.
They are allowed, my understanding, unless there's a reason not to, but they are allowed to have visits.
Senator Bolden and then Senator West.
Isn't this the bill that we spoke about, that they didn't have a facility in place to house these women or the baby or the liability associated with having an infant within the walls of a correctional institution?
So I didn't mean to cut you off, but I should have said in the introduction, the bill is contingent on the opening of the pre-release unit for women, which is currently in the process of being constructed, but it doesn't currently exist.
But does that pre-release unit that's being constructed have within its design a facility for newborns? Or the
That-
adaptation to
Yeah.
We pass this bill, then
but
in the course of the construction, they'll know that that's an intent to have those accommodations.
but you're self-admittedly saying that this is such a small number of people. Pardon?
The design phase hasn't even started.
But again, you're saying that this is such a small number of people that this would affect, but that would add a pretty significant expense plus staff to maintain oversight of it.
But maybe, I'm sorry, it's possible we would add something, but I don't think so, because I think that there's not a lot of people, so we're talking about, like, it's probably hardening off a small section where they're gonna be housed anyway, and just saying this is the area where they're gonna be and they receive the treatment.
So we would have to provide them with a separate area for them and the infant, and we would have to provide them with the proper furniture
You
and
mean like the
and-
hospital, like the delivery bed and then the bed where they would sleep anyway? And
No, I'm
maybe-
talking about
maybe-
like, are we gonna have the baby in there and not have a mother that has a rocking chair for her baby, or has the ability for a bassinet? I mean, there's a lot of things that go into this other than just the mother holding the baby for 24 hours a day.
I
Huh?
think that's kind of outrageous to anticipate luxury accommodations like it's the Four Seasons. It's
Well,
not that.
I agree. And I also agree that this is why we don't allow this now, because it's not the Four Seasons. So we should be looking at other avenues, either immediate family member or Department of Social Services to help facilitate a resolution until the release is completed. Because obviously they did something that has them incarcerated for longer than 18 months.
I appreciate your perspective, I just don't agree.
Okay. Mr. Chair, when you talked about the work group, is there any consideration of just making the parameters that we're talking about in here a work group instead of this bill, or are we voting on this by itself?
The bill before you is clean because we received budget and tax approval for that, but I put it out there that
We
you know,
have,
I don't want to mess with the bill, but
we have received budget?
we have.
Okay, thank you.
Thanks, Senator West and then Senator Kelly.
Actually, I don't need to ask questions. Those were my questions.
I just want to state that I really think this is a wonderful and important bill. And I read the ACOG testimony in support of this bill. I think the policies that Senator Carter was talking about in terms of envisioning the pre-release center as a place that's safe for new parents are really important. And I just remember Secretary Lopez coming here and talking to us about how it's a state priority to not necessarily place children in foster care where they don't need to be. And the ACOG testimony certainly supports that this would help with that. It says that newborns born to incarcerated mothers are separated from their mothers as soon as the mother is discharged from the hospital and placed with a secondary caregiver or in the foster care system. It's traumatic. It goes on to talk about the health implications, lifelong impact that this would have on the newborn. So I am just very thankful to Senator Carter for introducing this bill.
Priority, you should have a letter.
All right, committee, what's your pleasure? Do you want a roll call on this? Yeah. All right. Motions for favorable consent. Roll call.
Vice Chair Waldstraker,
Yes.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yeah.
Senator Folden,
No.
Senator James,
Yes.
Such a hard no.
Senator Charles,
Yes.
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Yes.
Chairman Smith.
Yes. There you go. Thank you. Senate Bill 71 passes 10-1. Okay.
Yeah. Oh, 1095 now. Yep. That was.
Just about.
But before you put me on, let me ask him something. Senate Bill 1095 reestablishes a work group on home detention monitoring to study home detention monitoring, both public and private. And it would be staffed by the Department of Public Safety and Correctional Services and would report its findings by December 31st of each year, terminating in 2027.
Do you have? All right, so right now, there are two representatives of the private home detention monitoring agencies who shall be non-voting members. I'd like to have one of them as a voting member. That's my amendment. Seconded. Okay, is everyone okay with recording that?
Just one and one?
One and one. So two members, but only one voting member. Is everyone okay with?
Is it necessary for that? I mean, if you're gonna have a vote, then why the two?
I'd still like to have, because look, right now there are five major players in Maryland that do this. The most high profile points of failure, frankly, on this have been where DJS had it. I mean, like the thing that happened in Brooklyn was
DJS.
DJS.
Not
That
private.
person was under DJS supervision. So I do think just going through this whole process through the kerfuffle with the funding through, and we're going to discuss this in the next bill about the actual timing for notification.
Mhm.
I've had a chance to kind of talk to these folks a little bit more, and I do think it's important to have them weigh in and provide kind of a 360, but not giving them undue influence on the thing. But
Thank you.
yeah, we're not adding another member. We're just switching one to a voting. Yeah, let me see. Double count. How many, Josh?
Of the voting numbers on
Yeah.
It is gonna be 16.
What's the organization?
So we're trying to figure this out for the voting. So if you make one voting and one non-voting, then you're gonna have 16. You could have an even number of votes. So yeah, this is what Senator McKay brought up. So what do you want to do? I mean, that it's a practical problem, but
I think an 8-8 vote would just be a failed vote. That's.
Do you care about that? I don't care. All right. No. With having them both vote? Well, then I think that gives them a little bit outsized influence, more leverage. It's too much. That actually helps my. All right, that's fine. All right, so, all right, one voting, one non, everyone's okay with that amendment. Now the bill's before you as amended, the motions for favorable. It's been seconded. Is everyone okay with being recorded in the affirmative?
Yes.
Okay, thanks, second, okay. I know. Senate Bill 1095 passes unanimously with amendment. Now, the more difficult one of the two is going to be Senate Bill 468.
Senate Bill 468 alters existing notification requirements for private home detention monitoring agencies. Those are the private companies that provide this service, to require them to make specified notifications immediately rather than on the next business day as under current law. There's an amendment in your packet, which is number 563821/1. The amendment makes several changes to the bill. First, it changes essentially what is the trigger for this required notice. So under current law, the notice is required when the person under monitoring has been missing for 24 hours. The amendments would change that to when the person has violated a term of home detention monitoring. In terms of when the required notice must be sent. So under the bill, it's immediate. Under the amendments, it would be generally within 24 hours. However, if the person enters an area which the court order expressly prohibits them from entering, if they tamper with the home detention monitoring device, or if they fail to properly maintain the device as required by the court order, the notice would have to be sent within 1 hour. And then finally, the amendments add civil penalties for companies which fail to provide the required notice. So the penalty would be up to $1,000 for the first day on which the notice is not given, and then $250 for each subsequent day that the notice is not given.
So just understanding the context with which all this is happening, this isn't the end all be all because the task force that we just passed is going to develop best practices and understand, bring the stakeholders together and kind of figure out how to reform this system. But understanding that we need to take action in this session on a system that is fundamentally flawed. These are a couple of steps that I think could make a difference that cuts down I think helps with the mayor's problem in particular, but all of our jurisdictions with the delayed notification. We worked with these groups actually. So we brought them in and talked to them about this, and they not the fines. I could say this on record that they feel like they can do this today if we pass this bill, and that it does mark a significant step forward. But understanding that we're still going to move forward after this task force makes their recommendations. So I just put the. Okay, so I just want to make sure that Senator Sidner has a chance to speak, then we'll move on the amendment.
Thank you. Just, so in one context, it says the monitoring the defendant shall, the monitoring agency will, for the monitoring, the defendant shall notify within 1 hour. That's at the bottom of the page. So then I'm wondering why are we changing the immediately to within 24 hours? I mean, somebody can really get out of the state if they wanted.
For the three new. So it's the exclusion zones, right? Josh, it's the exclusion zones. It's for the tampering. And for, I guess, what if the battery goes out or something? Or,
Yeah, I think they're generally required to keep the devices charged. So if they fail to do that.
So what's your specific question? So
On bill page 205, line 14, we've changed. Well, it was changed from on next business day to immediately to within 24 hours. And I'm wondering why not immediately? Because I was initially thinking maybe it was something that they just were not capable of doing. But if they're capable of notifying within an hour because somebody's tampering with, one would think that it would be a more serious.
yeah, so that's why we kind of fenced off these 3 locations where it's within the hour. For everything else, it's within 24 hours. But so these things, the examples, who else was in that room? Some of the examples were like if you were, I guess if you were working, but you stayed at work a little too late, and that's a violation. So that something of that nature would have to be reported within 24 hours. But there's something also called an exclusion zone, which is like, let's say if you're a domestic abuser or something like that, and there's, your victim is in the exclusion zone. If you go to the exclusion zone, that's a significant public safety risk. So that's within an hour. That's the policy.
So the serious stuff is within an hour.
Correct.
Okay, I'm good.
Yeah.
Thank you.
But that's, it's not as clean as that, but it's where that's going.
Gotcha.
Yeah. So Senator Carter and then Senator Folden.
Thank you. Just a quick question. And Josh, you essentially answered it maybe. I was curious about the requirement for the maintenance by the person using the home monitoring. Is there something beyond just the battery? Like what is their responsibility of maintaining the equipment?
So what I'm aware of is that they're generally required to keep it charged, but the language in there fails to maintain it as required by the court order. So if there were some other language in the court order, that would be captured by the amendment. But the condition I'm aware of is that they have to keep it charged.
And I mean, look,
Thank you, Mr. Chair. So my question is kind of piggybacking off of Senator Stidnor's, why we had it originally set at immediately, then it got modified to within 24 hours for this certain non-critical type violations. But then we loosened it on the serious violations to an hour. The serious violations is exactly what we're talking about and concerned about, as I understood from the testimony, because if you have someone that's on a part of a pretrial release related to a domestic issue, notification within an hour is unacceptable. It should be and be required to be for the more serious offenses, immediate notification so that they can then coordinate with law enforcement to have someone on site to locate the subject because clearly they are in one of these critical zones that others are in danger. So I think that by changing it to an hour, it would create liability by putting it in statute that it's, well, it was within an hour. Sorry about the person being assaulted or worse, being killed.
So I'm gonna give you two things. I agree with you, actually. I thought this was kind of a good starting point before the task force can go ahead and make their recommendations of the feasibility of all this stuff. But, and Shamari, I don't want to put you on the spot, but just because your background as a public defender, and if you're comfortable sharing this, like just some of what you've seen, it is possible today that a judge could say, hey, look, this is home detention monitoring. I want to know immediately if they do
Correct.
X, Y, or Z. They could say that today. So,
Yeah, but that's what my point.
So,
Like,
I mean,
why don't we
so-
make it immediately? Because an hour creates an opportunity for those that would be otherwise predatory against someone or in retaliation against someone who filed charges against them. That's one of the areas that we've crafted out of this. We should be doing our due diligence to protect them.
what do we say immediately for the exclusion zones?
There you go.
Okay, but for the tampering or for the whatever, not for all three, just for the exclusion zones.
What's the other two though?
Like failure to maintain your device and tampering with your device.
But if you're tampering with it, you're trying to get out. Why would we do that within an hour?
I'm trying to strike that. I'm
All right.
I'm trying.
I mean, I would rather see us do all three, but if we're willing, if we can go and do the one for the exclusionary zones, which are
And then the,
very critical.
okay. I'll take that amendment. All right, so for the tampering and for the failure to maintain our exclusion immediately. Is everyone okay with that?
Yeah.
All right. Yes, sir.
I had an amendment.
No, I agree. Thank you.
There's another amendment that we had in the folders that no longer being, it was your amendment 90332111.
No, we built on that because they said, you can explain it, but I think
don't-
that's subsumed into this.
Very good,
but
okay.
Yeah. Okay, so now, Senate Bill 468 is before you with amendment. Motions for favorable. Second, is everyone okay being recorded in the affirmative? All right, Senate Bill 468 passes unanimously with amendments. Can we go Shamari with Senate Bill 46?
Oh, 4-6.
46.
So Senate Bill 446, we voted on 46. There's some amendment language that I've received. It has not been drafted yet, though.
Yep, just to add that amendment language is consensus language. Everyone's come to agreement. So thank you to Delegate Foley, to condominium owners and the Attorney General's office. So we're good to go. We just need to draft it.
When we get the amendment, we'll do it. Yeah. All right, so let's move down a little bit. Senate Bill 118. This is, we're still waiting for budget and tax? Okay.
Yeah.
I will loop back again. They're shaking the tree loose a little bit over there.
I think I have to let.
From budget and tax?
Yeah.
Excellent. Okay, well, okay, let me know, call up and we'll come back to it. Okay, so Senate Bill 134. Okay. So apparently, Budget and Tax is gonna offer an amendment on the floor, which will enable us to pass this bill. So we're gonna hold this until we get that sorted out. And I talked to the chairman of Budget and Tax, and then we'll move forward. That's 134.
Holding that bill.
We're holding it.
I don't see the amendments. Are there amendments?
There are no amendments.
No,
There-
just not, so I'll get those distributed.
Because, oh, the interlineated copy is not in front of us right now. Okay, got it. That's what I meant, but that's fine. I know, because you didn't think it was gonna get voted, so. All right, Senate Bill 139, we're still waiting for budget approval. What about, okay. What about Senate Bill 174? But,
It says, oh, never mind. Just kidding. It says hold.
okay. Senate Bill 174 is still on hold. We are 282. I'm still waiting on that. Like the bill is good to go, but the funding is not. So, what's the amendment? It is. Okay, do you want to, who's the council on that? You want to go ahead and explain the bill and then we'll go.
So Senate Bill 282 is a departmental bill that repeals duplicative items from inclusion in GoCap's annual report to the General Assembly on opioid use disorder treatment by local correctional facilities. There is an amendment in your packet. It's number 543125/1. It adds to the requirements of the program that local facilities make certain opioid treatments available to individuals in custody.
Yeah, this is just doing some clarification, make sure that the program, which was passed back in 2016, is taking care of it, especially on the reporting end.
The current requirement is just general, and the amendment would specify some of the actual specific treatments that they're supposed to offer.
From it's not from Mako. Mako has where we're trying to get the funding on. And it's an option for that. But this is more streamlined, making sure that this trans musical part opioid is included in what they do already. It's actually been put on the cross file, not in the house.
Okay.
Oh, it has, great.
So the amendments are moved. Is that okay dropping the amendment? Okay. So now
Yeah, like
the amendment gets adopted unanimously. Now the bill's before you. We are going to still, so look, this is the funding for these programs is not contingent upon this bill. I'm just using this bill to have that conversation. What do you all want to do? Do you want to hold this and continue those conversations for funding, or you want to pass this bill?
no, I want to hold the bill for the funding.
Okay.
I
Done.
think it's a promise.
Sure, Senator James.
I think the other one that we're holding, but I guess they would work together, right? Because this would add some more options for treatment. But then we really need the other bill to fund it because, right, so that's still what we're trying to do, get that funding to relieve the pressure or unfunded mandate on local jail. Very good. Thank you.
So we're going to hold it, but the amendment is adopted, so we'll,
Light with the funding. So MDH is reporting 107,000 fiscal note on Senate Bill 801 and Senate Bill 282. Senate Bill 282 is a department bill assigned to JPR. Obviously went over to Budget and Tax for our financial. Mako doesn't believe that it's accurate that MDH needs the 107,000. And if Mako's amendments are adopted, Senate Bill 282 and 801 can be absorbed by the OOCC, which is the agency that staffs already the managing distribution of opioid funds and receiving reports. So just FYI. It's important. If you remember, Allegheny County talked about in the passage of 2016, but no state funding, it's costing Allegheny County about 800,000. And the state was supposed to pick up the cost.
I think it's important to say on record as many times as possible. So thank you. All right, so we're gonna hold that, and then we're now on to what about, so Jamie, 398. Do we have approval for that?
No.
Okay. 398 is held. All right, Senate Bill 452, we're gonna hold for one more day. Senator Carter, I think there's still some negotiations going on with the parties. Senate Bill 470, we're gonna hold. The administration's here. Jamie, where are we on? Are we 471?
Have not received approval.
Okay, so that's on hold. All right, so that's just, let's do this. Senate Bill 479, we had a work group established. Let's, Josh, I know we're riding you pretty hard right here, but I'm gonna give you a little break in a second. If you could just describe the amendments that were discussed, and then I think we adopted them last time we were here. We did not. Okay, let's just discuss the amendments and make some progress on this bill.
So the amendments are in your packet. It's number 823120/1. So they do several things. First, of the revenues that are collected by the State Highway Administration from work zone cameras, the amendments would direct the State Highway Administration to prioritize spending them on purchasing and deploying work zone safety equipment. The amendments would additionally require that work zones be equipped with signage at every entrance, and that the signage have flashing lights when workers are present at the work zone. The amendments would require these work zone cameras to be equipped with blue lights, which are flashing when the cameras are active. And then after an initial period starting on June 1st, on January 1st, 2025, the amendments would establish a system of graduated penalties for violations recorded by these cameras. And it would also require that fines from citations be doubled when the work zone is active with workers present. So if someone was driving between 12 and 15 miles per hour over the speed limit, the fines would be $60 or $120 if workers were present. For driving 16 to 19 miles per hour over, $80 or $160. For 20 to 29 miles per hour over, $140 or $280. For 30 to 39 miles per hour over, $270 or $540. And finally, if they were driving more than 40 miles per hour over the speed limit, $500 or $1,000.
Any discussion on the amendments or just doing? All right, it's been moved. So hold on, I think we have to hold the bill for a second, but I want to move the amendments on it. Senator West, go ahead and speak, and then there's been a motion. It's been seconded. It's open right now. We're going to vote it as soon as Senator West has an opportunity to speak.
I just had a question. I may have missed it. Currently, you have to have somebody physically sitting in a car in these work zones. Does this bill get rid of that requirement?
Yes.
Okay.
Feel that.
Fine, good.
The amendments been moved. It's been Senator James is seconded. Is everyone okay adopting? Sorry, Senator Kelly.
Oh, sorry, I'm okay with adopting them. I thought we had already done that. I just
Okay.
had a clarifying question.
Sure. Is everyone okay adopting amendments? All right, amendments are adopted. Senator Kelly, sorry.
Thank you. I just wanted to make sure, because it is my understanding, and I don't stay as up to date as many of you on this committee do on this topic, but that ENT considered doing these graduated fines, penalties, and they decided it was too complicated to do so. So there's going to be just a back and forth between the two committees at some point?
This is definitely going to conference, but I mean,
Okay,
With Senator Fulton, I mean, you can speak to the genesis of the fee
So-
schedule.
thank you.
The fee schedule comes in line similarly to what they have in school zones. When school zones are in place, you can drive through a school zone, but when children aren't present, you can go at the normal speed. When they are present, it's flashing lights, there's certain requirements, and then it's an escalator for violating it while there are actually children there. So modeling that, moving it to a similar thing in combination with what's currently in law and work zone, we just took those numbers, transitioned them to an unmanned to accommodate what has been absorbed and accepted as the 12-mile-an-hour over or under, 12-mile-an-hour or less as the acceptable rate of speed through those areas, and then modified it to have a fee with people there and a fee that when people are not there, but still in violation of the speed limit. So it becomes a bill all about safety, and that's what we were trying to accomplish.
Thank you very much. I just want to make sure process wise, so what we're coming out in a different posture and we're expecting to go to conference and figure it out. That's okay.
Yeah, that's right. That's my expectation. Also, I mean, we'll be in obvious consultation with the Lieutenant Governor as well to have her, but Senator Fulton, go ahead.
Mr. Chair, I was just going to say, and we're still working on some of the specific alignments because there was concerns about the original crafting of the language that it would allow for identifying the money is going to areas that would otherwise be not what the intent of this bill was supposed to be about, which was work zone safety. So we're working on that.
Josh, I know we'll hold this for another day or two, but we'll
Yeah.
figure out between Joel and
Sure.
that, but for where the funding would go, but maybe we could pull some examples of similar statutes and where the money, how the allocation's done. What did the House do on fines and what did the House do on allocation of money?
So I believe the House ended up at $250 as a flat rate for the citations, and the House did add some language allowing local jurisdictions who operate these cameras to keep some of that revenue, I think for specified purposes, but in the current law, all the money goes to the state, no matter who's operating the system. So that was one thing the House did.
All right, so we'll hold it and revisit it tomorrow. So Senate Bill 538, we just had another work session on this and we're going to continue to work. I think we'll have something by tomorrow. This is the non-economic damages.
Sure.
Yes.
Can I make a request to be on that conference committee that's?
Yeah. Oh, that one? Yeah. Yes. That was definitely going to be a thing. Okay, so we're gonna hold 538. Senate Bill, Shamari, where are we with Senate Bill 550?
That's ready.
Oh, we're ready to go? Excellent. Senator, we'll go ahead and enter the bill and then I'll give Senator Sidner an opportunity to speak.
So Senate Bill 550 adds labor trafficking by a child's parent or guardian to the list of conditions under which a local Department of Social Services is authorized to ask the juvenile court in a child in need of assistance proceeding to find that reasonable efforts to reunify a child with the child's parent or guardian are not required, and to expand statutory provisions related to the Safe Harbor Regional Navigator Grant Program to apply to child victims of labor trafficking. Labor trafficking means knowingly taking, placing, harboring, persuading, inducing, or enticing a child by force, fraud, or coercion to provide services or labor, or receiving a benefit or thing of value from the provision of services or labor by a child that was induced by force, fraud, or coercion. There is an amendment in your packet. That amendment alters the definition of abuse to include labor trafficking for purposes of provisions of law governing children in need of assistance cases and child abuse and neglect reporting. And it removes labor trafficking from the circumstances in which a local social services department may request that a court find that reasonable efforts to reunify a child with the child's parent or guardian are not required. If you look at your amendment packet, that is amendment number 473920/1. The House subcommittee voted on this amendment. There's one slight wording change. If you look at amendment number 2, number 3, to align with the definition of sex trafficking, it should read labor trafficking of a child by an individual.
No, that's what Shamari said. I think we talked about this earlier, so we were trying to make certain that things were aligned with over and with that, what was happening in the house, so. Move the amendment.
All right. Second. All right, now the bill is before you as amended. Further discussion? Motions for a favorable, it's been seconded. Is everyone okay being recorded in the affirmative? All right. Senate Bill 550 passes unanimously with an amendment, All right, Jamie, when you read it. Senate Bill 551. Is that ready?
Yes. Senate Bill 551 makes several changes to procedures related to the release of a person committed to the Maryland Department of Health after being found not criminally responsible or NCR. The bill establishes that the Maryland rules governing discovery and circuit court cases apply to a proceeding to determine eligibility for conditional release or discharge. It requires a court and MDH to promptly inform the committed person's counsel of record when they receive a report that a committed person violated a condition of release or violated conditional release, respectively. It requires a court, on request by any party, to hold a hearing after an application is made for a change in the conditional release of a committed person to determine whether the applicant has satisfied the requirements for release. It establishes that a preponderance of the evidence standard applies to an applicant in change of conditional release proceedings. And finally, it clarifies that a court may extend a conditional release by up to 5 years and authorizes a court to shorten or terminate the conditional release. There are no amendments in your voting packet.
It's
So this legislation was brought to me by the Office of Public Defender, and there was agreement between them as well as the Maryland State Attorneys Association for those, because I think they were having some issues because of the judicial procedures and the Maryland rules, that they were not obtaining the type of discovery that they needed. So this was an attempt to fill the gap to ensure that some of these hindrances or roadblocks that they were coming upon were able to be met.
No, I like the bill, but just wanted to give an opportunity just to talk about the judiciaries. Give an opportunity to address some of their concerns. All right, so they write, the language that the bill seeks to add to the statute provides that the circuit court rules governing discovery will apply to proceedings that determine release conditions for committed persons. It is unclear, however, whether the civil discovery rules or the criminal discovery rules would apply. Second, the bill would require the court to hold a hearing if requested by any party, including self-represented litigants, and permit additional hearings. This is unworkable. Further, locating the counsel of record for the committed person years later is not practicable, especially if they were panel attorneys. These issues may be more appropriate for the Standing Rules Committee of Practice and Procedure.
And an amendment on that, I will work on that and have that ready.
Excellent. Okay, we'll hold it, and then pending the amendment, we'll move forward with it. All right. Senator Fulton.
Real quick, I'm sorry, Mr. Chair. I just want to be clear. Why isn't this something that isn't going into the Standing Committee on Rules and Practice and Procedure. Why are we legislating this? I mean, if they're agreeable to it, they're both agreeable to it, state's attorney and the public defenders. And you've got the judiciary saying that there's things that are unworkable, but if you put it into the language of the three of them working together, as I understand it, in the Standing Committee on Rules of Practice and Procedure, I don't know that we need to legislate it. We can allow them to work it out within their own rules. That would be the way that I would think it would be, because there's clearly a solution that all three want, and they're the ones that are the stakeholders that would be abiding by those standing committee rules.
How long this is to have things go through their rules process. My suspicion is both the state's attorneys as well as the defense attorneys probably would not want that. But I will certainly talk as I get this thing drawn up though.
Can we ask them if that's doable? Because I think I would much rather do it that way than to have us legislate it.
I'll ask.
Thank you.
Okay, all right.
So I think is this Jamie, Senate Bill 858?
Senate Bill 858 authorizes a person or the Attorney General to bring a civil action for the non-consensual distribution of a visual representation, including what is defined in the bill as a deepfake of a person with the person's intimate parts exposed, or while the person is engaged in sexual activity under specified circumstances. Public inspection of court records in applicable cases is restricted as specified, and the administrative office of the courts must report annually to the General Assembly on the number of civil actions brought under the bill. There is one amendment in your voting packet. It is Amendment 723-123/1. That's Senate Bill 858, Amendment 723-123/1. The amendment strikes provisions of the bill as drafted and provides instead that a person may bring a suit for defamation per se under certain circumstances in which another person distributes a computer-generated visual representation that is indistinguishable from an actual visual representation of the person and falsely depicts the person with his or her intimate parts exposed or engaged in sexual activity. The amendment also alters the state's existing revenge pornography statute to include computer-generated visual representations and alters the elements of an offense under that section of law. Just a reminder for the committee that the sponsor had asked for an inclusion of a provision for attorney's fees for prevailing plaintiffs.
That's not in there now.
That's not in the amendment, no.
So I just want to understand. Jamie, are you saying that the original intent of the bill, which was to allow the Attorney General to bring an action for actual revenge porn, is no longer the bill, and it's limited to the defamation when the computer-generated images are actually false? They're not the person. It's limited to that now?
Well, so clarified, what the amendment would provide is two things, a civil piece and a criminal piece. As for the civil piece, it provides in statute that a person under those circumstances where there's a computer-generated image that falsely depicts the person engaged in that activity could bring a suit for defamation per se. I guess you asked if it limited that to that type of suit. I don't read the language as being necessarily limiting. That's just my interpretation of the language. The second piece, the state has a existing prohibition on distribution of revenge pornography. Things that images that depict a person with their intimate parts exposed or engaged in sexual activity. Under the current law, those that applies to real images, real photographs or videos, not computer generated images. So what this does is it actually takes language that's pretty similar to what the General Assembly did with the child pornography statute and computer generated images as it applies to that prohibition, and made uses that language to make the revenge pornography statute apply to computer generated images as well. That are indistinguishable.
So how much are we expanding the Office of the Attorney General? I'm not just talking about this bill. It seems like there's a lot of expansion over the course of a number of bills we're dealing with this session.
Right. So as amended or with the amendment, the AG would be out of the bill.
Oh, the AG's out of the bill.
Right.
Okay.
Right. Uh-huh.
This is a kind of an uncharted and novel area, so I mean, definitely warrants some discussion. If you have questions, keep them flowing, because Senator Walsh.
Listen, I actually take a pretty libertarian take on some of this stuff, and I want to make sure the language is tight. We used to have an organization that would help us do that. But even without that assistance, the language here is really tight. Like, I think this is good. I appreciate the opportunity to discuss it more, but I think the language is really good.
Senator Kelly.
I think the language is really good also, and I'm happy that we're having this conversation today with my daughter visiting from college. She's live texting me. She's finally interested in the bill we're doing, and I think that Taylor Swift plays no small part in that. So thank you. I really appreciate the amendment.
No, thank you, Senator Kelly, and thank you, Maeve, for gracing us with your presence here. It's awesome. Awesome way to spend spring break in JPR. In this nice JPR room with no windows on a beautiful 70-degree day in May. Oh. Well. Oh, well, that's different. Yeah, it's different. That's different. Yeah. Well, we definitely need more women in the Senate when we're on this committee. So, go ahead.
By a moment. And no, I'm not actually going to do that. I just have more of a rhetorical question. Given where our society is going and given the prevalence of photographs and digital images and videos, I'm just looking at the very tight language that Vice Chair mentioned in the bill, and it is tight language, but at a certain point, do you foresee a time when we will contemplate that it is no longer reasonable for persons to expect privacy in these images, given the prevalence of sexting, texting, and all kinds of other things? I'm not against it.
Look,
I'm absolutely not against it. I'm just saying that there was a time when there was a real expectation of privacy in your images, but given the way that society is going now, it's almost like a foregone conclusion that it could be shared, in my opinion.
That's like an existential question. I mean, that's true with your data. That's true with, I mean, it's, your PII. It's true with your physical location, your geolocation. I mean, yeah, I know, I'm just saying. Yeah, I hear you.
There was a time when I think we could all over an intimate relationship. We don't expect it to ever go out of here. But these days, I think we should all caution and advise everyone. Anything you ever take could come back to be exposed. And it's probably happened to all of us. Haven't any of you ever been at a meeting or an event and you know that someone could be filming you, but you don't expect it. And next thing you know, there's a video of you. I'm just saying, like,
Yeah.
it's very prevalent.
Also, I mean, look, or you think you have the mic is off and you say something really awesome. Yeah. So yeah, I mean, even kids growing up on social media now, it's different. It's different. Senator Sidnor, and then Senator, and then Council, you can speak a little bit to the First Amendment implications as well. Good.
I had two questions on it's the page after bill, page 4 of 1 is unnumbered at the top. B, so I guess it's 3-3505 B. A person may bring and maintain a civil action for defamation per se against another who distributes. It goes on. So I had two questions. One, the need for the addition of per se after defamation. Why are we adding per se instead of just saying civil action for defamation is the first question. And the second question is, it says against another who distributes, and I'm wondering, are we looking to just limit it to those who distribute, or is there a concern about those who create? So those are the two questions I just wanted to put out there.
I'll start with the second question first, which pertained to the distribution. And in the context of defamation, those are statements that are made to others. And I think with the amendment language, it's I guess prohibiting somebody through the civil angle of this from just creating would almost kind of be like saying that you couldn't make a statement to yourself. But with per se defamation, just sort of going back in my head about the case law on that, and I may actually look to Mr. Taylor for an assist on that since he does the civil law. But my recollection is that per se affects the proofs that are required. Per se defamation would include currently, and I may need to go back and read my source on this, but would include allegation that somebody had committed a crime, or that somebody had engaged in what's the word I'm looking for? Like falsely alleging that they had engaged in like sexual impropriety. So I think that that's where this fits, is because you're dealing with specifically sexual images that are falsely doing that. The image is the statement essentially that's saying that they engaged in sexual impropriety or something sexual that was false about them.
So there's no difference in, I guess, the elements that one has to meet from defamation or defamation per se.
That's the other thing. My recollection, and I'm not sure if Mr. Taylor knows off the top of his head. I can certainly go back and look at my notes here to give you the answer. If you could wait a second, but my recollection is that it does affect the proofs that you have to make out, depending on if it's defamation or defamation per se. And if you give me a second, I think it may also have to have something to do with a public figure versus somebody who is not a public figure. But let me verify that for you.
Appreciate it. Thank you.
All right, you want to just, we can jump to another bill while you do that, or you want, or do you have enough time? Okay, great. Excellent. All right, let's go on then to the next one I want to do is, I think you as well, Jamie, but oh, wait. All right, we're going to talk about 155.
So Senate Bill 155 establishes a regulatory framework for local jurisdiction to use noise abatement monitoring systems to record violations of state law governing maximum sound limits for motor vehicles, and authorizes the use of such systems in 3 counties, specifically Anne Arundel, Montgomery, and Prince George's. There are 3 amendments in your packet. The first is number 303-524/1. This just adds sponsors. Number 713-428/1 removes Anne Arundel County from the bill And number 843228/1 clarifies that the systems would only record violations where the sound limits exceed the maximum by at least 5 decibels.
Let's just, I don't know what we're gonna do with this bill right now, but can we just adopt the amendments and then we'll work off of that? Is that okay? Adopt the amendments? All right, now the bill's before you as amended. Further discussion, go ahead, Senator Folden.
So did we get any feedback, Josh, on the tractor and trailers and Jake brakes, or, you know, they're braking because theirs is significantly louder than a common motor vehicle?
I did not receive any information about that.
And then did we also get clarification from the manufacturers? Because now it's only 2 counties then, because Anne Arundel wanted out. So we're talking about which 2 counties? Okay.
Yep.
My shocked face. Did we get any details back from the manufacturer about how specifically it is able on roadways that are more than 1 lane? Because that's the only video they showed was a vehicle in a single lane. When there's multiple vehicles in a row, how it's actually able to track and determine which specific vehicle it is, because it's not like radar where you're actually seeing a visual depiction of a vehicle going faster than other vehicles, and you can make that relative to the speed indication on the camera. This is something that is an audible infraction that is not something that draws your attention by the camera to be able to physically see it and then address it solely when there's multiple vehicles around, I guess is my question. Have we found that out yet?
I have not received any additional information. My understanding is there's an operator who would have to make a judgment call on
A judgment,
which vehicle to
a judgment
issue
call.
us. Yeah.
Mr. Yeah, I'd like to hold it because we don't even allow police hardly to make a judgment call anymore.
Wow.
So.
All right, bill's held for
Thank
one more voting session. All right, let's go to the Sandy, can we do one? So we did adopt those 2 amendments, but
Because there were already amendments adopted.
the task force, I think of just a Senator Folden.
Yeah.
So let's do this right now while you're still looking this up. For the home monitoring attention task force, we have a supplemental person, so we can take off. I'd like to bring that back just to consider one more amendment.
It was 1036, right?
Yes, before 68. The task force is 1095.
Or
Okay, so we amended that bill to have one of the members of the industry to be voting. So that's good, keep that.
right.
But then it posed that problem with the even voting. So what's your amendment? You want to substitute?
Yeah, so I don't want to substitute. I'd just like to add, because in the other bill for Senator McCray in Baltimore, which deals with this same thing, the monitoring system, we've added in the Maryland Network Against Domestic Violence, or their designee, the executive director of the Maryland Network Against Domestic Violence, or their designee, but we didn't have it in this bill, the 1095, the work group on home detention, which is a statewide bill. So I think it would be appropriate to add them in there. Then it would also give us the 17th member, which gives you the breakpoint, voting number. And it's also, like the example we gave was relative to DV, which is everyone's concern.
No, I think it's a very good addition. It makes perfect sense. And they're a voting member.
And they'd be a voting member. So I'd like to make that amendment to the bill.
Makes sense. All right. Sandy, what's the proper motion for this? Can we just motion for this and add it, or do we have to reconsider anything?
Reconsider.
Probably reconsider.
Okay, so we're gonna reconsider the vote by which Senate Bill 1095 passed. Is that okay with that? All right, great.
Second.
Now the bill is before you with the amendments. We got another amendment which is Senator Folden's amendment to add this voting member, the Maryland.
It's the Maryland it's the executive director of the Maryland Network Against Domestic Violence, or their designee.
Which is the same executive director that was added to the
Correct.
Senator McCray's bill. So, all right, is that
As a
okay
voting member.
Voting member. Is everyone okay with that?
Yeah.
All right, great. Now the bill's before you as amended. Motions for favorable, but been seconded. Is everyone okay being recorded in the affirmative? Great.
All right, thank you.
All right, thank you. All right, I think now we're ready to move back to. Are you ready, Jane?
Yeah.
Okay, go ahead.
So actually gonna defer to Mr. Taylor on this one for the answer.
Okay, just for the record, we're clear. We're back on Senate Bill 551.
Thought it was 858 or,
My apologies, 858.
so Senator Sidnor, your question was why damages or why defamation per se in Senate Bill 858. And so defamation per se is when the nature of the falsehood is so egregious that a plaintiff doesn't have to prove actual damages suffered. And so it involves actual malice on behalf of the defendant. And so I think the justification in this bill is that the nature of these false images of identifiable people is such that it should statutorily just be a per se defamation cause of action.
Thank you. And defamation per se versus defamation, what's the difference in the test? I mean, what elements?
The only difference is you do a defamation per se claim, you don't need to prove actual damages. And so normally under defamation, there has to be some damages from the false statements.
Gotcha. Okay, thank you.
Senator James.
Sort of following up on Senator Senior's questions. I don't know is there an amendment in front of us to allow for the recovery of attorney's fees, or is that more of a conceptual thing that we're dealing with?
That was, it was conceptual, and that is not before us, and I would,
Oh, okay.
I don't think we should do that, but
I thought we were.
yeah.
Well, I
yeah.
did reach out and talk to the sponsor, and
Okay.
she was amenable to any other thoughts we had about it. And so if it's up before it's ready at this moment, I will hold off on that, sharing that, all that. All right. Thank you.
It was about the attorney's fees. And
Didn't we have a discussion about it?
it's all open for discussion. We're good. All right. The bill is before you with this amendment. So we have not adopted the amendment. So I'd like to make a motion to adopt the amendment that's before you. So second, so now the bill's before you as amended. Further discussion. There's a motion for favorable. It's been seconded. Is everyone here okay being recorded in the affirmative? So I'm sorry, hold on. All right. We're good? All right. So Senate Bill 858 with amendment passes unanimously. All right, we're gonna go to Senate Bill 1097.
Senate Bill 1097 requires a person or entity operating a gun buyback program to destroy a firearm, including every component and part attached to the firearm that is traded in at a gun buyback program. The destruction must make the firearm and every component and part attached to the firearm permanently inoperable and irreparable. A person or entity may contract with a law enforcement agency, an organization, or a business to satisfy the destruction requirement. A person who violates this provision is subject to a maximum fine of $10,000 per violation. If a violator is a licensed firearms dealer, in addition to the maximum fine, the Secretary of State Police must revoke the person's dealer's license. Excuse me. There's one amendment from the chair in your voting packet. It is Amendment 583-727/1. That's SB 1097, Amendment 583-727/1. This amendment is different from the amendment that the committee considered on the past voting session on Friday. This amendment amends the bill to include various provisions relating to firearm safety and firearms crimes. However, unlike the amendment from Friday, it does not contain a provision pertaining to licensing of handgun instructors by MSP. As a reminder, the amendment contains the other provisions from last week's amendment. It would exempt DNR employees carrying out official duties from provisions of the restriction on wearing or carrying in sensitive locations, which were established last year under Senate Bill 1. It classifies theft of a firearm as a 5-year felony. It alters the gun buyback provisions to apply to FFLs and law enforcement agencies and makes various other changes to the buyback language in the bill. And it also classifies trafficking of regulated firearms as a felony.
Okay, move favorable on the amendments. Is it okay to adopt the amendments now? The bills before you as amended. Further discussion. We can talk a little bit about, yeah, we took out the the training piece is just, we're still working on it. We have another vehicle in the committee to do this, just not on this bill. But if we find out, if we can work with state police, we will continue to do that. And we have plenty of other vehicles in committee that we can attach it to. So I want to do it, and you can speak to the importance of it. Up to you. Senator Fulton.
No, I just wanted to actually, because this is a pretty hefty amendment package. It's like 10 pages. Can we just, I mean, I don't know how much discussion we want to have, but can we just hold this until we get a chance to review them? And see the implications, as well as the discussion about the training, which is a separate thing.
Sure. I'm probably going to keep the training off of this though.
Yeah,
but
that's fine.
Yeah. No, I hear you.
It's a hefty amendment. I just wanted to be able to review it.
We're going to put it on a different, we're still working out with MSP, like how to make this work. So we're still working at it, but I'd rather, I don't want it to complicate this. There really are 4 parts of this bill. One's the gun buyback, which I think there's pretty much consensus on there, from all the stakeholders on that. 2 is the DNR amendment, because it's something that we omitted during Senate Bill 1, so to allow DNR police to carry in some of these sensitive locations in case they have to, perform any of their duties. And then it's the trafficking and it's the theft of a firearm. There's basically there are 4 components of it. So.
Okay.
I'd like to move the bill. I don't want to hold it. But I do want to, we did adopt the amendment. Yeah. But I'll give opportunity for folks to take a look. We'll come back to it at the end of the voting session. We did, yeah. We have plenty of vehicles for the training if we figure that out, just which I'm interested in moving, so. All right.
Training was one of my favorite parts of the bill.
Me too, but it just, we're not there yet for the training, but.
I'm reading through it, so please forgive me for not knowing where things are, but the part where we're talking about the trafficking and theft and making them those felonies.
Yep.
What's the current, and I'm just maybe blanking, tired maybe. What's the current penalty for illegal sale?
Oh, I don't know. I know possession is a 5-year misdemeanor. If you are a prohibited person, it's a felony. If you possess an illegal firearm, it's a 5-year misdemeanor. So for illegal sale, I don't know.
I mean, trafficking is ostensibly selling
A
except it's
bunch.
more
Yeah.
general. It could be volume or not volume. And I'm asking the question, huh? You're not talking.
Which statute that would fall under? Well, I mean, if it's a regulated firearm, then it's us. If it's, I mean, if you're not doing the 44, let me take a look at it. No,
I'm happy for you to get back to me, and I think it's probably obvious why I would ask such a question. I feel like a lot of times we put so much of the burden on a possessor, albeit illegal possessor, who may or may not have committed a crime with it. And many of us know that people often possess firearms illegally more than we would like. because one, they just don't feel comfortable or they're not really acquainted with the legal process, but they may be in a situation or an area where they feel like they must have a firearm for their own protection or protection of their family, just based on their circumstances. I'm not excusing or forgiving the illegal possession of a gun, but as we're looking to felonize it with no real vehicle down the road where they could overcome a conviction of a felony for mere possession of a gun, my concern is that we have some type of at least parity, because in my view, the sale and trafficking is much more heinous than the possession. Because sale and trafficking, you're literally infusing illegal guns or putting them into the streets or putting them in the hands of someone illegally, and you know it's like it could be for no good purpose. That's much more heinous act than the mere possession. So that's why I think that as we go down this road, we at very least look at the trafficking and a sale.
Yeah, I would say that, so first, we're not making possession a felony. It's the theft is the felony. And right now, you know, it is over 1,500, it's a felony. The value of the item that's stolen is a felony, below is a misdemeanor. Right now, possession of an illegal firearm is a 5-year misdemeanor, 5 years. And based on the price of the firearm, most of which are not $1,500, it's going to be a misdemeanor of what, 2 years? A maximum? 5 years? And a fine not exceeding $10,000. There you go. So, got it. Thank you. So, it's not the possession. We're not felonizing the possession of a firearm. It's the theft.
So I think that we probably are.
Unwittingly. And I'm just going to speak about this because
You're going to talk about merger issues.
I
but-
believe that
yeah.
we really are. If you've ever looked, and I'm happy to supply this committee with a sample, I didn't come prepared today with it, with a sample of a charging document. I don't know why it's folded. I'm sorry if I'm like, but you know this. If you've seen many of them, you've seen charging documents for illegal guns, right? And you've seen that there could be up to 16 different charges for one gun. And so inevitably, the theft of any stolen gun is going to be charged, whether the theft can be proven or not. And then it's going to inevitably be used as a tool to inspire some type of a plea. And in this case, we're felonizing something that may or may not be able to be proven, just like with the automobiles. All automobiles that are charged as a theft, even where they can't be proven. Every single time that there's a vehicle in the possession of someone that doesn't own it or shouldn't be in it, they're charged with theft of the vehicle. Even where the state knows they cannot prove the actual theft, they can only prove they were in possession of the stolen automobile. This is common practice. So the same thing that happened with a gun. And so the issue that I have is we know that's going to be the case. And we know that inevitably we're going to create more felons by passing this. And we still leave no vehicle or mechanism for this person down the road to overcome it. And so by creating a felony for someone that could be 18 or 19 years old because they are charged with this and made a felon when they may or may not even have done an actual crime of violence or any crime, they just in the possession of the gun. We create no opportunity for them in their entire life to overcome this felony conviction. And so I think an intelligent thing to do, given all of the information that we have today about what happens when we create felons and we create no opportunity for them to ever recover from the felony, we ought to create a mechanism where someone down the road that does everything right, whether in possession or theft of the gun or mere possession of the gun, we ought to create a mechanism for them to be able to overcome this felony conviction.
No, I agree with that piece of it. I mean, I think this is an important policy discussion to have because, and this is where my mind is at, because so post Bruin, we learned last year that, and this is from Maryland State Police, they have, they were traditionally giving about 10,000 HQLs out every year. And then when Bruin passed, they did well over 100,000, which means they were doing more in a month than they were doing in a year in years past post Bruin. And then I looked at gun sales in Maryland and who has that number at the ready? It was like several hundreds of thousands of guns. So with this post-Bruin world that we're in, which I'm not happy with, but we're here, you're just going to have more opportunity for gun theft because more firearms are going to be just in the stream of commerce, that's just where we are. Okay. That's just like the accepted reality of where we are right now. And so with the proliferation of firearms just out and about, and we've made secure locations, so now firearms are going to have to be in cars, and of course they're going to be required to be stowed away, but that's not always going to be the case. You're going to have more firearms subject to theft, and that are going to be subject to falling into the wrong hands. And so I think this is an important discussion to have, and that's why. Second is, if you have a nice watch and you steal it, that's a felony. If you have a nice item of clothing or anything over $1,500, that's a felony. Everyone in this room voted to felonize the unlicensed practice of dentistry just last year. If you know it, now you do. So these are the policy choices that we have to make. And I put that context out there because that's where my head was with putting this forward. I do agree with you that we do need to provide more options for expungement and for people to get relief.
Or maybe not even expungement, I'm sorry.
Or or whatever. Yeah. I mean, yeah, but I'm glad we're having this discussion out loud, and that's why
I don't actually think everybody in the world is entitled to an expungement. I actually think that people should have their circumstances considered, and we should consider expungements for good cause when good cause is shown. But even the examples you gave, it's my understanding or my recollection that we even created a mechanism, and I don't know that I personally agree with this, for people convicted of theft to get expungements, So I'm concerned about the whole firearm thing because there's a stigma attached to it, especially if you live in certain areas and you're part of a certain culture. There's a stigma attached to it that you have a conviction, a felony conviction for a theft of a gun. You are not fit to do anything in this world. You are not fit to work here. You're not fit to live here. You're not fit to go to school here. You're not fit for anything. And I just think knowing that we have this proliferation of guns and knowing we haven't done enough to stop the trafficking. We haven't done enough to stop the influx. We haven't done enough to stop the illegal dealing. I just think that it's wrong to overdo it on the low level person that we are burdening with this conviction that won't be able to overcome it. And so at the very least, we need to create that opportunity for someone to overcome the conviction. Just like we talked about a lot about rehabilitation, we talked about a lot of things. We allow, we need to expand opportunities for sentence modification. We need to expand opportunities for expungement. We need to have judgments based on decisions based on discernment of the individual and stop these, arbitrary situations where the dentist can be a felon and maybe not get it expunged, but the theft of the watch can. It just doesn't make any sense. And I'm really concerned about this because, I happen to come across people all the time that are in court taking pleas on various gun offenses. And now we're just adding like another layer to something they likely to take a plea to. Not to mention the pretrial situation where there's a gun. They're not going to see the light of day for a release decision prior to their trial. I don't know. I just think this is a political move. And I get it that certain people across the aisle agree with it because it doesn't likely affect any interest that they have in 2A. But it affects the interest of the people that I represent and the people that I care about. And that's why I'm speaking about it. I think that we need to do better. And we need to create opportunities for people to overcome these felony convictions, because once they're saddled with a felony, they're relegated to a life of perpetual second-class citizenship and likely criminality. We're actually pushing people into an arena of criminality when we don't allow them to be legitimate citizens.
Thank you, Mr. Chair. Senator Carr, look, I hear you, and I hear a lot of solid points, and I think what I hear, so I'm going to confirm what I think I'm hearing, because I may be a little off. But the one thing I want to preface all this with is that, much like the chairman said, and this is what my plea was during the hearing, we can no longer afford as a society to only attach the monetary value of the device that's stolen but we need to be considerate and mindful of the threat that the stolen item presents to society. And we all agree that the theft of a motor or of a handgun is a serious violation. But right now there is nothing in place to really make someone think twice before they take it when they break into a car or whatever it is. So it's an important element that we understand and attach the threat that it creates for society. You brought up some things about the stolen car versus unauthorized use and all that. I don't want to go down that, but earlier we just passed a bill today that out of or second reader where we can have now we're going to let people that are convicted, not charged, convicted of jury tampering, bribing a jury, serve on a jury. I mean, that's ironic to me. I mean, but the path back. So do I hear you correctly when you're saying that the path back to legal gun ownership after this? So you're agreeing that this is something that we need to address and take head on in a serious manner and are supportive of this, with the idea that we create in the future, a path back to legal gun ownership, or to have a measure in place that there is an expungement criteria for certain things, or did I miss the point on?
I think that, it could include a path to legal gun ownership, but I'm just asking for people to just have a right to be a citizen. Like, just gun ownership would be great.
I agree.
But a lot of people, they just want to be able to feed their family.
Sure.
Right? They just want to be able to go work at the Walmart.
Yep.
I want a pathway for people to be able to overcome these convictions.
Agreed.
Because if we don't do it,
Understood. Thank you. I'm good. I've read the amendment, so I don't know if everybody else is, since we spent this much time on it, can move forward with the bill.
Yeah, I thank you, Mr. Chair. I think Senator Carter has brought up some really good points. As you are aware, I'm a strong believer in second chances. I passed the Juvenile Restoration Act over my governor's veto a couple of years ago. This year, I introduced the Senior Restoration Act. I believe in second chances. And that would include expungement. And if you expunge a felony, then you're no longer a felon. And it means that I would assume that you now have a right to own a gun again. However, that's not this bill. That's another bill, a much bigger bill. So I don't think we should not pass this bill, because we're not going to incorporate in this bill expungements of all sorts. It wouldn't be just this felony, but lots of other felonies would be included as well. My suggestion is we're going to do this study of a recategorization of all the criminal offenses. That work's going to begin this summer, assuming the House passes the bill we passed already. When we get to the end of that, we will have all the offenses categorized. At that point, it seems to me be totally appropriate to do a complete study of expungements of everything from A to Z, and see where we come down on all those different offenses in an organized, systematic way, rather than doing what we have been doing, which is pass an expungement of this and expungement of that on a one-off basis for the last couple of years. Let's do it in a systemized way.
So I hear you about it's not this bill, but here's the deal. For decades and decades, this body passed bills to be tough on crime and have very large sentences, in some cases mandatory sentences, creating felonies. We now know better. We know the consequences of those actions in a way that people didn't realize or care about 10, 20, 30, 40 years ago. So now that we know, when we are moving down the road to creating a new felony, I think we have a responsibility to think about the unintended consequences. And so that's all that I'm saying. And I hear you about we're going to look at this and weigh that and the other thing. But to be honest with you, we need to really move on in the direction of letting a decision be made based on the person deserving an expungement, rather than just some arbitrary, this was the crime and that was the time. That's where we need to go. That's what we need to do.
Thank you. See, I think what I was hearing, what I heard you say, and it may not be what you intended to say, but I think was a thing of, if we're creating felonies, we have to look at the entire the entire ball. It's not just the creation of the felony, but it's also the punishment that goes along with the felony, but then it's also the exit ramp of how one then deals with rehabilitation and or reentry back into the world as a returning citizen. And if we are looking at the creation of new felonies in that way, I think you're looking at them more whole. And it would be legitimately a part of this legislation if we're looking at the creation of these types of things, of felonies in that manner. Again, I don't know if that's what Senator Carter was saying, but that's what I was hearing her as she was talking. And I think it legitimately makes sense. I mean, you think about nowadays because of something that transpired this summer, whenever we create the task force, now we're saying, you know what, if there's certain behavior, we're going to now tack on to these task force bills the ability for those who appoint to be able to remove. So I mean, it's the same type of thing.
No, I think this is great. I think this is a really great discussion and is why this is an awesome committee. So, I mean, all right, this motion to move the bill. And there's been a second. All right, just one more. Senator Carter will speak and then I'll speak and then we'll do a roll call, I guess. But just to,
Thanks for giving me the time.
yeah, of course. No, this is a really important discussion. I think it's a great, I mean,
Sway anybody's mind. I
No,
just
no,
think
no.
these things are important to be said.
yeah, absolutely.
And I'm frustrated with the way that we do things. When we don't think about the unintended consequences and when we create more problems than we should under the guise that we're doing some good for society. I will finally say that inevitably, and when you get the data reports back from this, you will find that theft will be charged when it cannot be proven all the time. And state's attorneys will say all the time to the defendant, listen to this, because this is what's going to happen, because it's what happened every day with the car thefts. If you plead to the theft, which is a felony, and I got a felony on my record, everything else will be dropped, and I'll recommend probation, like a deal that's too good to turn down. So you're not thinking about, I'm saddled with this horrible felony for something that they can't even prove. You're like, oh, but I'm not going to have to serve much time. Or if you plead to the felony theft, which I can't prove, I'll drop everything else and you'll get 6 months. The point is, this bill is going to be used to felonize people all the time, even where there is no evidence that they took a gun, because that is what happens every day with the auto thefts. They are all charged with it. And then if the state can get the felony, they're very, very happy. And they'll offer like no jail time all the time. And who's going to turn that down? Nobody.
I think possession is always going to be easier to prove than the theft. I hear what you're saying about the charging regime, but the possession is still going to be a misdemeanor. Not changing that with 5-year misdemeanor. So it's hard. I mean, look, it's you're going to have more guns out there in society after Bruin, not just in certain neighborhoods, but in all neighborhoods. And it's a policy choice based on the price of the item. Is still a nice watch felony still fine?
That's a misdemeanor, I believe, still.
All right, Senator Sidnor, go ahead.
I'm just curious, and because I have not gone through the complete bill, is there any type of reporting requirement on how state's attorneys are going to be using this? Again, because that's something.
Everyone understands the component parts of the bill. So the gun buybacks, the trafficking, this theft. All right, the training is out.
Vice Chair Waldstreicher,
Yes.
Senator Sidnor,
I'll pass at the moment.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
Yes.
Senator James,
Yes.
Senator Charles,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Yes.
Senator Carter,
Yes, as to the gun guy buyback and the trafficking. I want to separate out the other part of the bill.
Bring an amendment.
Let's hope it dies in the House. Which I know there's no.
Senator Sidnor,
Yes.
Chairman Smith.
Yes. Just so you know, everyone on this committee has passed more bills than I have out of this committee. All right. Every single one. All right. We're now going to go on to Senate. Do we, Senator Kelly, are we ready for Senate Bill 905? I think that's Jamie.
Me to reach out to both Hopkins and University of Maryland. They had provided testimony on the bill in support of the bill, and they had given some information about the confidentiality procedures for the information from ERPOs that would be collected from the court records. I reached out to Hopkins and received a memo that is actually in your voting packet. It says Senate Bill 905 on the top right-hand corner. University of Maryland, I had not received a response as of this morning, but Senator Kelly's office reached out and provided links to the IRB guidelines, I believe, correct me if I'm wrong, Senator, for the University of Maryland and Johns Hopkins. I've not had an opportunity to review those, but would be happy to forward those to the committee. Okay.
So you got it. So do we need to go ahead, Senator Bolden?
Did we find a solution for, this is the one about the ERPOs? Is that what we're talking about?
Yes.
With the educational institutions, did we get clarity, or do we have an amendment to require that they be?
No amendment is in your voting packet. What is in your voting packet is a memo. The folks at Hopkins had been watching the voting session on Friday and had prepared a memo for the committee based on the questions that the committee had been looking for answers to about how they handle the confidential information.
Okay, but we like to make sure, like, you can put a memo together and it's like, hey, this is what we won't do with it because we're responsible educators. However, what I will tell you is that may be the institution's feelings about it. However, these are individuals that are going to have access to people's identifying information. And that is not an appropriate, it's not a tracked element within the study, as I understand it. And it should not be an inclusive part. There should be, what's the word I'm looking for, Jamie? Not shielding, but it should be
Redaction.
redaction.
Sure.
It should be redacted. There's absolutely zero contributing positive factors that come out of putting people's personal identifying information out there, because these study of these ERPOs doesn't even have to be an active ERPO. It could be one that was applied for, but was found to have no merit.
I hear where you're coming from. I happen to disagree. I think that this is how all the other states do it. We have the federal guidelines in place. There's details of the protocols available in your packet. I mean, I understand we see this differently, but I feel a strong level of confidence that our research institutions can comply by these rules. And if there are any individual actors who are not, then there's consequences that are laid out for those actors. The institution could lose their funding. The individual actor would likely be fired. I really think that the benefit of passing this bill, which again, we understand from the judiciary, the redaction is financially not feasible, but more importantly, I don't think it's necessary because of the federal guidelines. And I just want to sort of point the committee to the written testimony, talking about the public health benefit of being able to do this research. I would hate for us to miss the opportunity for the public health benefit of being able to do this research because of a need that I don't think exists for redacting the records. So I just, again, want to have the committee focus on the fact that they're looking at, why are the ERPO petitions being filed? Like, how can we reduce suicides by guns, right? Are the ERPO petitions working? Who are the authorized petitioners? To what extent are judges granting suicide-related petitions at temporary and final hearings? This is the kind of research that we need to be done. And I think it can be done under the existing federal guidelines, just like the other states do it. And if we were to engage in the redaction that is being suggested by Senator Fulton, it would be cost prohibitive for us.
Counsel, how much, I mean, look, I 100% agree with you what you're saying. And this letter from Hopkins, I think it more than satisfies me for the privacy concerns. But counsel, do you have an idea as to how much it would cost if you were to require redaction?
So judiciary had put together some numbers on the cost of doing redaction between analysis, programming, testing, and project management. Their estimate, and I don't think that all of this would be recurring, although some of it would be $514,000.
Wow. So how many were issued last year across the state? So it would be an important number to understand, because if we're talking about $514,000 and we only had 514 ERPOs requested in the entire state, you're going to tell me that we should have, what is that, $10,000 per piece of that? It's going to cost $10,000 to redact and send that out for, I mean, that just sounds ludicrous.
And provide a breakdown on their costs. The cost breakdown for programming and testing, those seem to be the biggest costs. So I think that's your upfront
and that's not
cost.
A renewable one.
I wouldn't expect so. So programming, they estimated would be just north of $225,000. Testing would be it would be around $108,000. And then insofar as analysis, $98,000. In project management, $83,000. So I think that those two are probably your recurring costs.
So about $170,000.
Right.
Is what they're estimating on an annual basis it would take to redact.
And that could account for pens right.
Well, 80,000 of it is for a pen.
Right.
For the person to do it, the manager.
Well, for the analysis, right.
But then the analysis. Yeah, I don't see that. I don't see the number that we have of ERPOs being requested being to that degree. I just don't. I mean, I know how many at the agencies I've been at that they've done, and it hasn't been in the hundreds. It hasn't been to this degree. And while I think that the reason for the study is a good reason that they want to be able to do that, I think that people's privileged information is their information and should not be out there for public purview, especially when we're considering that some of these measures may not have even been found to be valid. So that's some of the analysis of this data, that they're going to have people, how many times did they ask for it and it wasn't provided, it wasn't given because it wasn't justified. So now you're going to be putting people's information out there that wasn't found to be merit or found to merit an ERPO being given. And then, or if it is given for the 7 days, then they go to court and the judge says, no, this is not appropriate, they throw it out. Now these people have privileged private information of someone that should never be given out, and they were not convicted of anything. But if it's put out by the wrong person, there is irreparable damage done to that person and their reputation. There is zero reason I can think of for this type of analysis to be done that we couldn't redact it. It just seems simple enough to do. Then you can have the study.
I kind of want my friend Senator Carr to go first. She might have a good idea here. Because she's smart. I would just say that I think that the research institutions are really accustomed to and used to working with confidential information. This is not the first time they have done this. And I would also point the committee members to the point in the memo underneath considerations on redacted court records where they talk about their concerns, the concerns related to their research if their ability was limited by redactions, because I think that that was informative for me. And I could read it out loud to you all, but I trust you all to read it. I just think I would note that this is how the other states do this. And I think that there's a lot of precedent for this. And I think that the federal guidelines, federal requirements are strong, and I would urge us to pass it without the redaction.
Thank you. Sorry for making anybody have to go back over something that may have already been covered. Is this are these accessible at would they be accessible at any stage of the process? Like right upon the filing of the petition, or would it be after there could have been a dismissal, denial, or even a consent, and then it could have been shielded? Or is it at any time, or is it clear when it would occur?
That it's at any point in the proceeding. It's just that there is a court record, and that you know, it's not restricted from access to these researchers is what the bill would be providing.
So the researchers would be able to see it was dismissed, it was denied, it was consented to, and shielded upon consent. Would they be able to see a shielded one?
Well, I mean, do we? Right, we don't shield ERPOs as far as I'm aware. So,
Extreme risk are not shieldable just because they're extreme risk?
well, it's a civil protective process. So, and I wouldn't imagine that there would be a need to shield it, because currently there are only 6 types of individuals who are authorized to see the records anyway. So they are confidential generally, which is what the bill is dealing with, is just adding the 7th class of individual who would be able to access them.
And under and Senator Kelly talked about the federal regulations, and I haven't read the memo actually all the way through. Is there currently a penalty for breaching the confidentiality for anybody, not just the potentially new category, but anybody? Is there something in law?
Under ERPOs? No, I'm not aware that there is.
There's something in Health General. I'll see if I can.
So for general compliance with institutional review boards, which I think is what Senator Kelly was just referencing, under section 13-2004 of the Health General article, the Attorney General does have the ability to seek injunctive relief or other relief to prevent the conduct of human subject research in violation of federal regulations on the protection of human subjects, which Hopkins has indicated the confidentiality would fall under this because of their IRBs. And I'll just read from the statute: in exercising the authority granted under subsection A, the Office of the Attorney General may not duplicate the investigatory compliance or enforcement action undertaken by an agency of the federal government, or bring an action under this section if an agency of the federal government has determined that an investigation is not warranted. So those would be the restrictions on it. But generally they can seek a court remedy for compliance.
I understand.
But as far as I'm aware, it wouldn't, there's no monetary or criminal penalty for failing to comply.
So perhaps that's something that the committee should consider, either now or down the road. And since we're kicking the cans down the road for a lot of, unintended consequences remedies. But the reason I say that is we do allow for, penalties when people breach like an expungement order or when people otherwise breach confidentiality. Perhaps a penalty for violating the confidentiality should be something that we consider. Because we've really never run from the idea of a penalty.
James, excuse me, and then.
Thank you. Senator Kelly, you might know, I heard you say, this happens in other areas in the state of Maryland. So that's my question. I was reading the statute that we're trying to amend, and it says all court records relating to a petition for an extreme risk protection order made under this subtitle are confidential and the contents may not be divulged by subpoena or otherwise, except, and then there's some exceptions. So what other areas in Maryland that have this kind of level of protection are also accessible to research institutions? That, so I could look at, because you indicate this happens in other areas in Maryland. So I'm looking for that.
Was actually saying was this is how it works in other states. However, this, what the reason I had my light on was to remind the committee that we passed legislation, I think it was 2021. I'll pull it up, but we passed legislation to allow for this particular data to be part of a research project through the Attorney General's office. So,
Right, I
and
read
that's sunset. So it had been happening already in
I
Maryland.
know, but
Yeah.
that's under the AG. I'm just,
Yeah.
maybe I misunderstood you. I thought you said, so I'm looking.
No, what
that
I
there
said
were-
was it happens in all the other states that have this, do it this way without the
So
redaction.
you're not aware that there.
I'm not
that-
aware of the other, no,
You won't
I
let me
can,
finish my sentence, but that's okay. Just
Okay.
because if everybody's gonna listen to the record, it's fine, but just it's better for people who will listen to us later for them to hear my full question and then your full answer, but we'll stop. That's fine.
Okay. All right, further discussion.
I'd like to hold the bill, if we still got questions about it, because we don't have any penalties with it, and it clearly violates she brought up the Attorney General's office, but the Attorney General's office, that's. I'll do it. They're attorneys, not interns, not students at a university that are allowed access to privileged information. This is a terrible policy standard that would be opening up a lot of issues for confidentiality that's already in law that people are protected by.
No, understand the legitimate concerns. I have the same concerns. My concerns were assuaged by the letter provided.
But it's not legally binding, Mr. Chairman.
No, I understand that. I understand that. Senator Kelly.
I don't know what you guys want me to do. It sounds, no, my light was still on. I definitely appreciate Senator James' point that we don't, I can ask the advocates for a specific answer to your question and see if they can point to other areas where they have research with information that is should confidential, and maybe they can come up with an idea to also address Senator Folden's concerns. I don't know. I'll bring it back to them and we'll see what we can come up with. Do you want me to move it just as it is? I mean, we could vote it out and then just, I'm comfortable with moving it. So let's move it. And then we can do a roll call vote and I will still get answers to those two sets of questions. And you could change your vote when we get to the floor if I can adequately answer them.
Just for favorable, it's been seconded. We'll do a roll call. I'm sorry. Yes.
Precedent for that? Right, understand that. That's not my question. My question is, do we want to be, from a process standpoint, going to the floor to be able to then, upon further knowledge, we now want to kick it back to the committee?
No, that's not what I suggested. I'm sorry.
Yeah, yeah.
But
He could change his vote for the floor vote.
Look, this is just a decision that folks have to make. I'm personally comfortable with the information provided to cast my vote. If other senators are not, then vote it down. And then if you get further information on the floor, then you can change your vote. I'm personally comfortable with it. I think several other senators are. There's been a motion, it's been seconded, so we'll run it. That's a policy. That's just a personal choice. If there's more information that we amend things on the floor, it happens all the time. It's very rare things to get recommitted, but if there's something that, yeah. No, yeah. But I think.
No, I just asked, I think we mentioned, for example, where this.
Or if they were not allowed, what were the policy considerations? So that was, but I don't have that information.
Thank you. So yes, sir.
I was a reluctant yes on the red flag bill several years ago. And I will be honest with you, took a lot of grief back in my district for having voted the way I did. Because I've got a lot of Second Amendment people back in the district who thought that my vote was akin to being a traitor. Literally, I was called a traitor. It was a hard vote and it was a close vote. One of the reasons I voted that way was I believed that all this information about people's mental health issues and other sorts of things would be protected. The possibility that it could be disclosed is hard for me to process. I would be far more comfortable voting yes on this bill if we had some language in the bill which would try to offer whatever protection we can to people that their personal information would not become public. I appreciate there's a letter from Johns Hopkins, but this bill is not limited to Johns Hopkins in terms of who could research and get this information for research purposes. I admit feeling uncomfortable that people could get the information and somehow, because so many computers are hacked these days, the information could get out into the public. So I just want to make that clear before the vote is cast.
Vice Chair Waldstreicher,
Yes.
Senator Stibnar,
I want to say yes, and if I can say, I mean, I'm satisfied with this letter. And if one thinks about all of the research that is done on people, there's all sorts of information in these organizations. They know how to protect people's privacy. So I'm not at all apprehensive of voting yes.
Senator West,
Pass.
Senator Muse,
Yes.
Senator Folden,
To comment on my vote, this letter from Johns Hopkins isn't worth legally the weight of the paper that it's written on. It means nothing. It has no legal standing for court. It just says we're going to be good stewards, and we promise we'll be good stewards. That is not a measurable standard in any bodies anywhere in the court of law. And that we already have in there protections that these are to be confidential because these people have not yet been found in violation. There's going to be people in there who are gun owners who have a estranged girlfriend or boyfriend that's upset with them, is going to go and file for a protective or an ERPO, and these people are going to have their firearms taken from them. They're going to have to go to court And then the judge is going to say, nope, that's not what happened. That's not it. We've got to give them back. And in the meantime, now this person's information, which was required by law to remain confidential, is no longer. It will be out for a study to happen. And it only takes one person to see somebody's name they know, to take a snapshot of it with their phone and put it out, because we just talked about, Senator Carter just brought up that we live in a society of people that have cameras and should expect all this information to be out there. And this is another example of that. This is someone that's going to have eyes and they're going to be like, oh, I'm going to keep this a secret. And they're going to take a picture of it, and there is zero liability associated with it. There is zero penalties associated with it. And we're giving them a permission to violate the rules of law regarding confidentiality. I think this is a terrible bill. I think this sets a terrible standard. And I happily, while understanding the purpose and intent of the bill, this is enough. By not, we shield everybody's information for every crime that they've committed. These people have not even committed a crime at this point. And we're going to not protect them by requiring the redaction of that information. That in and of itself should be a crime. And with that, I say no, and I encourage everyone to say no, because this is a bad precedent-setting measure.
Senator James.
I do want to comment just a little bit. I very much support the idea of research in this area, particularly as I think the federal government's taken a position where a lot of issues around gun and gun violence has been prohibited. So that is not why I'm about to vote no. But I am about to vote no because we certainly are in the driver's seat here and could put all kinds of requirements on the research institutions to enhance their protections they would provide. That I'm sure there's way over my pay grade, but software, hardware, all kinds of things to ensure more privacy, less potential hacking. I mean, we've done nothing other than just say they can have it. And it flies in the face of just I'm just thinking of HIPAA and things like that, where we're so worried in this modern era that things get out into the ether. And yes, they become available to people that you don't want to have see it. And I also think it's a small pittance to ask them, if not to add all kinds of security features, which I don't understand what they would be, but I know they exist, or redact. Because again, I see things getting hacked all the time. Information that should never be in the public gets out into the public. And so I want the research done. But I want it done with guiding principles of how we protect people that we have already put into law. And this bill asks for nothing in return. So I think that's not the good policy of the state of Maryland. So for that unfortunate reason, I have to say no to this bill. I hope we fix it so I could support it.
Senator Charles.
Yes.
Senator Kelly.
Yes.
Senator McKay.
I was a yes in the hearing, but now I believe I'm a no.
Senator Carter.
Yes.
Senator West.
No.
Chairman Smith.
Yes. I think there's a commitment on behalf of Senator Kelly, myself, and Vice Chair. We'll continue to develop more information, understand, provide. Hopefully, we can bring everyone back on board. Okay. We're going to move on. I know it is, but so Senator, you were saying this first, kind of controversial, but the quality of debate in the last two bills. I mean, this is really great. I mean, I know people are mad now because they took, but the dialogue has been really great. So this is awesome. All right, we're now going to move on to Shamari. You ready to go? Senate Bill 488.
Senate Bill 488 prohibits a firearm industry member from knowingly creating, maintaining, or contributing to harm to the public through the sale, manufacture, distribution, importation, or marketing of a firearm-related product by engaging in conduct that is unlawful or unreasonable under the totality of the circumstances. Requires a firearm industry member to establish and implement reasonable controls regarding the sale, manufacture, distribution, importation, marketing, possession, and use of firearm industry members' related firearm products. And 3, establishes that a violation of these provisions is a public nuisance. In addition, the bill authorizes the Attorney General to bring an action against a firearm industry member for public nuisance caused by a violation of the bill's provisions as specified. And 2, a person who sustained an injury or loss as a result of a violation of the bill's provisions to bring an action for damages against the firearm industry member as specified. The bill's provisions are severable. The bill takes effect June 1st, 2004. There is amendments in your packet. And that amendment removes the ability of an individual to file a private cause of action against a firearm industry member. And it requires that firearm industry members report certain information about trace requests to the Attorney General. And it also provides that information provided to the Attorney General is not discoverable under the Maryland Public Information Act.
So one, can you read the amendment?
The amendment number is 343-328/01.
You want to adopt the amendment and debate on the amended bill? All right, this is a motion to adopt the amendment. Yes, just, oh, Shamar, can you do the, so on page 2 of the interlineated copy,
Yes.
we're bringing back language which is line 17 and 18. For the amendment, just make sure that everyone knows that's part of the amendment.
Line 17 and 18 of,
Page 2 of 5 of the interlineated copy.
oh, yes. And yes, line 17 and 18 of page 2, intended to be sold, manufactured, distributed, or marketed in the states. That is going to be re-added to the bill.
We've adopted the amendment. Now the bill's before you. Debate, Senator West.
Well, just as, what do lines 17, 18 mean? Intended to be sold in the state. Means if some manufacturer in Iowa manufactures some guns and they're in a box to be shipped to Maryland, and then they're taken out of the box and sent somewhere else, there's some, this bill affects those guns that were in the box in some way?
So without getting into specific hypos, I think that provision is establishing a specific intent element as to where the firearms are sold. So if they are shipping to Maryland, I would think that would be covered under this bill.
But it already covers firearms that are distributed in this state or possessed in this state. Not what is this intended to be distributed in the state? I don't. Again, the only thing I can come up with is guns are in a box sent addressed to Maryland, and then at the last minute, for whatever reason, they're taken out of the box, or there's a new shipping label attached to the box, and they're sent to Montana instead. Those would be guns intended to be distributed in this state. What other examples can you come up with that we would be interested in other than that kind of a thing?
I'm not sure exactly how that would apply in practice, but
Well,
this,
then why are we going to put this language in the bill? What does it mean? What does it mean? Is my question. Apparently this language was added, somebody wanted this language added back into the bill. Why?
So intent has to be proven. And so if even if the act isn't complete, then you can still utilize the legislation. So if there is a trafficker who's trying to take illegal guns into Maryland, but the gun doesn't come in, but there is proof of his intent to do so, then the statute still applies.
But I assume the Attorney General isn't going to bring an action for guns which were never delivered in Maryland. If there were such a trafficker, my assumption would be that he would in fact have delivered guns in Maryland and it would be actionable because of that, not because he slapped a new shipping label on some guns somewhere else and diverted them to Montana.
This is civil offense, obviously, it's not a criminal offense, but I think it's analogous to like in the criminal attempt, criminal world, an attempt. The civil action is allowed to be used where the act is intended, but not necessarily completed. And so that's what we're getting out here. Every other state that has the statute has the intent language.
Oh, okay, so we're just basically copying bill in some other state, and this language was there, so it's in the bill here.
That act, but yes.
Okay, thanks.
I'm sorry, I am looking at some amendment that took out the language that Senator West is concerned about, so that makes me think I don't have the right amendment.
Yeah, so that's a change we did in the amendment, so the amendment to be adopted for school is that language, everything else is the amendment.
And Senator West knew all about that and I didn't. Okay.
It's to be adopted.
All right. Well, I don't remember that. Okay, so everything in this amendment except add back that deleted language of intended to be sold. All right. Add back.
I should add, Mr. Chairman, that there is a cross-reference that needs to be corrected just based on the retabulation. It's not substantive, though.
Thank you, Mr. Chair. So, I know we had this discussion and I appreciate some of the concessions that were made and the revisions and the amendments. But I do still come back to the idea that the Attorney General's office has, we should not be giving them just carte blanche authority without some type of complainant to go and take legal action against people that, now, did that revision change it for outside the state? It didn't, right? They're still allowed to go outside the state to other states. So there's no, we can allow the Attorney General with no complainant to go on their own on taxpayer dollars and go after, whether it be gun manufacturers, ammunition manufacturers, whatever it is, in other parts of the country, without a complainant here. And they're doing this, I guess under the guise of consumer protection, but understanding that we're talking about many other things here, like we were talking about the theft of a handgun being a felony, and we have other things that we should be looking to address here regarding our enforcement and strategies to solve gun violence. And one of our solutions is to give the Attorney General carte blanche authority without a complainant to go and seek legal action anywhere in the country. I think that's I think if we added in that as a matter of consumer protection at the request of a member of the public, that they would be able to look at something. I mean, that is far and away better than just giving the blanket authority for the AG to do whatever he wants against whomever he wants regarding this specific industry anywhere in the country.
So I'm sensitive to that concern. I think, I know it's meant in a very legitimate way. So just to use your consumer protection example, so let's imagine a real sketchy industry like reverse mortgage industry, for example. Under current law, the Attorney General would have the power to bring consumer protection case against the reverse mortgage industry, players in the reverse mortgage industry, producers, marketers in the reverse mortgage industry. Under most circumstances, they're going to have a complainant to do so, but they're not legally required to do so under current law. So they could bring a suit against a bad actor in the reverse mortgage industry under the consumer protection statute, but they wouldn't necessarily have a complainant to do so. So I do think you want to, even though most of this is going to be driven by survivors of gun violence who, you know, go to the attorney generals, tell their story, and then the attorney general brings it on their behalf. Under current law, you don't legally restrict that for other industries. So I'm not sure it's wise to kind of go about special carve outs right now.
And then what about the part about, you know, because under the ATF, the US code on 18 talks about that. Did we make, is this the part that was removed when it says that all such data shall be immune from legal process, shall not be subject to subpoena or other discovery, shall be inadmissible in evidence, and shall not be used, relied on, or disclosed in any manner, nor shall testimony or other evidence be permitted based on the data in a civil action in any state, including the District of Columbia, or federal court, or in an administrative proceeding other than a proceeding commenced by the ATF to enforce the provisions of Chapter 44 of such title, or a review of such action or proceeding.
Happy to answer that question. Really, really good question. So that language is not in 18 USC. It is budget language, not in 923. It's not found there. It's not statutory language. It's budget rider. And it's something called the TR amendment. The TR amendment does not apply to private actors. It applies to the ATF, which is obviously federally funded, and local and state law enforcement agencies who receive federal funding. So private actors are not you know, are not subject to that because they don't receive the federal funds referenced in the budget rider.
Yes. I think I just want to make sure I can characterize the amendment. Primarily what we do is just take out private actions, but leave in place that the Attorney General could bring actions. Is that just generally, would that be the right? And I so want to bring down gun violence and proliferation of guns. It's, you know, but what I'm worried about is that, as I said, when we had the hearing on this bill, I don't see us in any way advancing that desire through this bill. I mean, I'm sure that people have been told this will help, but I would suspect, and if I could, I would love to do a study before and after this bill, and I'm quite sure that gun violence will not be reduced under this bill. But what I'm really worried about is, if I were an attorney, I am an attorney, if someone came to me asking me how they could comply with this law, make sure they don't run afoul of this law, I would be at an absolute loss as to explain to them how they could comply with this, because to me it is hopelessly vague. I don't understand it. I don't think most attorneys will. I'm sure the gun owners won't. And I want people to be law abiding. I want them to promote safety. I want them to do everything they can to make the world safer. But if they don't understand how to comply with this law, then they won't be able to take any meaningful action under it. I'm so sorry that we weren't able to make the bill better.
Thank you, Mr. Chairman. So it was addressed in the hearing by some of the opposition, and I'm wondering if this amendment addresses it. I don't think it does. How does a industry member take steps to minimize the risk of liability then, with the unknown of our AG would never be political, but we don't know who gets elected in the future. So how does one in the industry minimize the risk of liability?
Me for Shamari?
I don't know anybody. I don't know.
It's a political question, I think. Yeah.
So as we talked about during the hearing, we encourage good behavior in our society in 3 different ways, right? We do it through our criminal statutes, we do it through our regulatory statute, and we do it through our tort. And under tort law, there is a pretty standard, longstanding reasonableness standard that we utilize in all aspects of our tort law. And it's been utilized, it can be utilized against us individually, it can be utilized against corporations, and has been for years. And we've talked about the examples of opioids, and I know that impacts your community greatly. And those lawsuits that emanated from your part of the state and your part of the country have done dramatic work in reducing the abuse of corporations that were flooding our streets with opioids. Does that mean we have no more opioid problems or dealing or addiction? Of course not. That wasn't a silver bullet. This isn't a silver bullet either. But when one industry is immune from one of those 3 aspects, then the regulatory stool falls apart. There's one leg missing from that. And so this provides the Attorney General with all the tools that we utilize to keep people and corporations accountable in Maryland.
Would this apply to, as much as we've tried to curtail drunk driving, and we've got bills here that we're trying to pass in support of and that kind of stuff, in any way can this open up the door for, say, this bill, but a future bill to open up the door for, we've got precedent in the gun industry. Why don't we charge, I don't know, Chrysler or Dodge because somebody was driving drunk, driving their vehicle? If it was something that was a actual manufacturing problem, gearbox, whatever the case may be, I can understand them getting, but just because they were using that car, isn't that the same vein when it comes to the firearm industry?
So during the hearing, we talked a little bit about this, and we used the example of the Ford Pinto. So they had a design that was purposely designed. It wasn't a manufacturing flaw. It was purposely designed. It wasn't a flawed design or a flawed manufacturing, but they put the gas in the back of the car and chose to not install an $11 piece of machinery that would have protected the occupants. And when that car was struck from behind, it would occasionally explode and kill the occupants. And so under current law, auto manufacturers are liable under certain circumstances. And I imagine this policy will work very similarly to that. When people are struck by drunk drivers, they sue the driver. They don't sue the manufacturer. But occasionally you want to retain the ability to sue the manufacturer. And there has been liability for manufacturers. There were liability for airbags that you probably recall, airbags that were misfiring. That was more recent. There was liability at some point, I think, for Ford Explorers that would tip over. I'm not sure if I'm remembering that correctly. That's a little bit longer ago. And so just because sometimes there is an intervening cause where the manufacturer would not be sued, and I agree with you that it would not be appropriate for them to be sued, doesn't mean you want to immunize the manufacturer behind it. So no, this isn't the camel's nose for to go after other industries. All other industries except this industry are already subject to the tort liability that this bill seeks to.
And you brought up some really great points, 3 or 4 or 5 or 6 of them. But there was a common thread: flawed. They were flawed items. If this bill had to do with a flawed firearm, it didn't trigger, it didn't it didn't work properly, that would be one thing that they should be sued upon. But what you're talking about is being sued, possibly sued over somebody using the vehicle, using that particular industry's, not because it was flawed, but just because it was being used in a public nuisance activity. So, thank you.
Thank you, Mr. Chairman. So I want to echo the concerns of Senator McKay. All those examples you gave, including the Explorers, which was not a design issue with the Explorer, it was a tired design issue through Firestone. The bigger concern I have here, and I'm hoping that it gets heard very loudly because I can speak up louder if I need to, because this is a big issue, is we have unlawful versus unreasonable. We have referenced in the bill, referenced in the testimony, that public nuisance is defined as any conduct that interferes with the rights of the public. The rights of the public. And there is a constitutional right called the Second Amendment that allows people to own those firearms. The bigger problem here is that there's already federal legislation under PLACA that addresses this. And, you know, firearms manufacturers would be no different than in the examples you gave with vehicle manufacturers, in that, is there liability on a firearm manufacturer for faulty manufacturing that causes a catastrophic weapon failure that causes injury or death to the one firing the weapon? That's my question. The answer is yes. Mr. Vice Chair, I'll ask it again. And they're the examples you gave, unless you're ready to answer it. I mean, I don't know if you heard me or not. No, it's fine. In the examples you gave, they were all about manufacturing issues, liability associated with that. It wasn't with a reasonable standard. It was liability on issues that are known to be problems, or that they should have known were problems when they designed them. And so my question was, is there liability on a firearms manufacturer for faulty manufacturing that causes catastrophic weapon failure that causes injury or death to the one firing the weapon? Would there be liability on that manufacturer in that instance? Because that would be a comparable instance to what you're talking about.
So I don't think that's necessarily analogous, but the answer to your question, as we discussed in the hearing, is yes.
It's very directly correlated to what you were talking about with the Pinto and other things like that, that there was an issue there. And that was a design issue, not purposely. They didn't purposely design it so people would die in those crashes. It was a design issue that when they were made aware of it, they didn't remedy it right away and allowed other people to die. So the bigger issue here is, again, it's very broad when we talk about a public nuisance, any conduct that interferes with the rights of the public. And my response to that is, again, what about those that are legally, lawfully allowed to own these weapons? the 2A, which is a constitutionally protected amendment. Whether we like it or not, it is the Second Amendment that our forefathers felt was important enough to address. The other component of that is, and we've lost the whole committee almost. Unlawful versus unreasonable. These are two entirely different thresholds. Two entirely different thresholds. We cannot convict anyone, especially in a criminal case, for an unreasonable act, because it is it's a subjective standard. There is no standard to it. So when we put that kind of language in here, and that it says, now we're going to add in there that a firearm industry member shall establish and implement reasonable controls regarding the sale, manufacture, distribution, importation, marketing, and possession of a used firearm industry, blah, blah, blah. These are already regulated by the ATF. So they're following the rule of law. So does Maryland think that they should be able to create a new law that is better than the ATF? And I'm blown away that we want to say that the things that are in this are not covered by the ATF, because the ATF actually does create and maintain that. So now we're putting this on the firearm industry.
So, yeah, I actually agree with you 1,000% that you can't convict someone based on a reasonableness standard. That would be wholly inappropriate. I think I saw the public defenders out there who would also agree that's wholly inappropriate. So this isn't a criminal statute. This is a civil statute. Reasonableness is the standard for civil statutes throughout our tort system and throughout the history of the tort system, which even predates our criminal justice system. So, and so I hear what you're saying, but because this is in the civil side, it mimics our current civil structure.
Well, again, I'll close out with, this is a very, once again, we give blanket authority to the state, to the Attorney General, to do a job that is not within the scope of how he's done, with no limitations on funding. Even when the Attorney General was suing the former president, they had a $1 million cap on that. We're not putting any cap on this whatsoever. That is reckless when it comes to taxpayer dollars for something that will do zero to reduce gun violence in our state. So thank you.
I just have maybe the vice chairman can explain it to me, or just, I'm trying to read PLACA and all that. So is the statute, or is the bill now, it still requires proximate cause, right? Is that the statute, whatever you've done here, it does require proximate cause, right?
It doesn't change the kind of standard by which the tort system works. Correct. This is not an alteration of tort standards.
So proximate cause would be required.
Causation, yes, causation. Yeah.
I'm sorry, what did you just say?
Causation would be required. That's exactly right.
And then I think the predicate exception allows, right, lawsuits to be brought as long as there's a violation of existing state or federal law. I guess the way I'm reading that is that you're understanding that the exception is that if there's a knowing violation of state or federal law, then a civil lawsuit could also be brought. That's the predicate exception. Is that right? Isn't that right? I guess, right?
Waiting for the mic.
I'm just trying to refresh my own memory. So what I'm asking then is, is your understanding that the bill you have, in other words, is it your understanding that this bill would still have to comply with that predicate exception? In other words, one of the various restrictions that are already out there, somebody in Maryland then knowingly violates one, then the Attorney General could then bring a civil action as long as there was causation between the harm and the action of the gun manufacturer or seller. Is that how this statute works?
Yes.
Okay, so we really are tracking PLACA and keeping it, so in other words, if it isn't a violation, I'm sorry, hold on. If it isn't a knowing violation of a state or federal statute applicable to the sale or marketing of a product, and also it has to be a proximate cause, those are the two requirements, then the Attorney General couldn't maintain an action. Is that how this bill works now? Is that how it works?
So the answer is yes. So this is designed to create a predicate offense under PLACA. That will obviously litigate, but that's normal.
I think we're
case
talking
like this.
across, I'm just trying to make, because if I have a gun manufacturer, I have a gun business, whatever, ask me what this bill does. I want to make sure I'm not incorrect. So I'm just saying, I read the predicate exception and I want to be pretty literal. It's basically saying you can bring a suit so long as knowing violation of state or federal statute applicable to the sale or marketing, and the violation was the proximate cause of the harm for which the relief is sought. Is that what this statute does? Your bill.
Yes, that's exactly what
All
it
right,
does.
thank you.
Okay, thank you very much, everyone. All right, so here's what we're gonna do. Obviously, we do authorization, but not appropriation, and there's a couple things that I think we're still figuring out on this bill, so we're gonna hold it. We'll revisit it, but it's good. We got some of the arguments out. We made some progress on the bill. We adopted some amendments. Sorry. Oh, yeah, and it'll be the first bill we address when we come back. We got a break tonight, so we're gonna cut this down. Tomorrow morning, we have that one bill hearing at 9:30. Then we've got floor, and then we'll do voting, but we'll keep things kind of moving and fluid. To my mind, the matter before us is the most, I think this will be engenders the most discussion than anything else that we have left at committee. So we should be cruising along. So with that, we're gonna call it, and we'll be back on tomorrow morning at 9:30 for a bill hearing.